Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Morning and welcome to the Court of Appeals. As you know, we've been working on Zoom for some time now, and it seems to be working pretty well. And we appreciate the fact that y'all are engaging with us this morning. I'd like to introduce our panel: Judge Armstrong from Memphis, Judge McGee from Savannah, and I'm Judge Golden from Memphis. Mr. Hivner, do we have anything else we need to address this morning?
No, Your Honor.
You may call the first case.
Paul Zachary Moss versus Shelby County Civil Service Merit Board.
May it please the court. I'm Andy Clark from the Memphis Shelby County Bar. We are here on the case, and I represent Zach Moss. As the court knows, this case has had a little bit of a torturous history through the appellate courts. Mr. Moss was a firefighter and was involved in an incident on November 1st, 2013. On November 2nd, 2015, he received a Loudermill notice that identified two violations: that he had been convicted of a felony and that he failed to notify Shelby County of the arrest. Those were in the Loudermill hearing, Loudermill notice. A Loudermill hearing was heard on March 13th, 2015, which resulted in his termination. And the termination letter set forth the same two charges that the Loudermill notice said, and affirmed his termination and terminated him. That was appealed to the Civil Service Board, who held a hearing in October of 2015. And at that hearing, the Civil Service Board upheld the termination. During that hearing, though, there were numerous objections made about the failure of a witness to come, using evidence of disparate impact or treatment of other employees, and that there was not substantial or material evidence. That case was appealed to the Court of Appeals, and Judge Golden issued an opinion and found that the notice was not sufficient, even considering both the pre-termination and the post-termination letter. But that was appealed to the Tennessee Supreme Court, who reversed that decision and held that the totality of the circumstances between the pre-termination and the post-termination letter afforded sufficient notice of the charges. However, the Court of Appeals did allow issues that had not been addressed by the Court of Appeals. It had remanded it to the Court of Appeals for consideration of whether or not the board improperly limited the scope of examination of Mr. Mayfield, whether or not the board denied us the evidence, the opportunity to present evidence of disparate discipline, and whether or not Mr. Moss was denied his constitutional protections by the failure to confront his witness, as Mr. Ezell didn't appear. And that's what we're here today for. We're here on back from remand from the Tennessee Supreme Court to this court to address those issues that were pre-terminated in the original opinion. With respect to that, while the court held that there was no denial of due process by the way the notice, the Loudermill notice and the post-termination notice were handled, I think that is still something that the court should look at the totality of the circumstances. And all I'm saying is, in judging all these evidentiary issues, you have to understand that when I went in there, I was fighting two particular charges, or that's what I felt I was doing. And those charges at the hearing were proved to be false. He was never convicted of a felony. That has been determined by both the Court of Appeals and the Supreme Court. Number two, he did notify people of his arrest. He did that. All right. And so the issue then is whether or not they could discipline him or terminate him for issues other than were set in the actual charges. And it's interesting to note that when I tried to deal with this civil service case, when I went down there, it is almost indescribable how to try to deal with these cases in this function. In this particular case, when I went down there, we had people hearing this matter actually laughing during the hearing. It was an offensive hearing, Your Honor. We weren't allowed to bring in any type of evidence of other people who had committed far more serious crimes, and were not even allowed to bring it in. They wouldn't even allow me to make an offer of proof to present that evidence in the case. And the interesting fact about that is Chief Benson testified, and this is kind of the where the rubber meets the road in my case. So he says, in this case, you are handling this instance. This is at page 72 of the transcript. You're handling this instance is how you would uniformly handle any instance similar to this one. And Chief Benson's response is, it's very simple. One of our rules is if there is a domestic incident, and if the employee is the primary aggressor, and if there is a weapon involved, that is a termination. It's a terminable offense. And all employees understand that. So that is the standard that Chief Benson applied in this case. It's not in any of the rules of the actual department. The department has two sets of rules in there, and his standard that he applied to this case does not even fit. There was not a domestic incident in this case, right? So we're saying that the standard that they applied to actually evaluate this case is incorrect. And even if you apply that standard, it results in that they did not prove this. There was no domestic violence incident in this case at all. Number two is when we attempted to try this case, in front of the civil service, I had issued an administrative subpoena for one of the primary accusers in this case, Mason Ezel. And he did not show up for that. And according to the case versus Shelby County Civil Service Merit Board, they held, we believe the Supreme Court's observations on due process mandate that where the facts giving rise to the employee's termination are in dispute, or the gravity of the termination as opposed to less severe disciplinary measures is reasonably challenged, due process requires the employee be afforded the opportunity to confront and examine witnesses against him.
Mr. Clark, did you seek a continuance because that witness did not appear?
I did not, Your Honor. And if you look at the record originally transmitted to the Court of Appeals was missing page 22. And on page 22, I raised the objection. I said I wanted to move forward. There was a discussion of how many continuances were already requested. One was requested, there were already two continuances, and the board said we do not continue after two continuances. So the answer is it was being discussed. I was told that the board did not grant continuances after a second continuance on page 22 of the transcript.
Now, in regard to your statement about not allowed an offer of proof of disparate treatment, you were prepared to show that there have been similar incidences where a firefighter was not terminated because of such conduct, domestic conduct involving a gun, or any conduct involving a gun that was off duty.
I had, to be honest, the person that I identified at the hearing had been accused and was still on of sexual battery. I had a whole stack of things in there, Your Honor, that I was prepared to prove as I do civil rights work. I know how to prove policy, practice, or custom, but that was all objected to and was not allowed. I mean, there was a very detailed discussion about me trying to make an offer of proof in the record.
All right. In administrative hearing matters, is there any case law that indicates that that's error and reversible, where that offer with regard to disparate treatment is denied?
I have not found any case that addressed an offer of proof at a civil service hearing.
Well, are there cases that indicate that it is appropriate to offer evidence of disparate treatment in these administrative matters?
My time is up, Your Honor. With your permission, I will respond to that.
Yeah, go right ahead.
The case that we cited is City of Memphis versus Catron. It's 2011 Westlaw 1902167. And in that case, it says that we note the weight of with respect to evidence of disparate treatment, that it is supposed to be given to the weight of the evidence to be determined by the trier of fact.
Okay.
Thank you, Your Honor.
All right.
We'll hear from the appellee.
Good morning. If it pleases the court, my name is Megan Smith, and I am an attorney with the Shelby County Attorney's Office representing Shelby County, Tennessee this morning. To start, I would like to recap, the situation. And we did have an employee here of the fire department who was involved in a political rally that ultimately ended up in a physical altercation and this employee pulling a gun on two citizens. He was Loudermill. In that Loudermill hearing, he was asked a series of questions by his fire chief, by his deputy fire chief, regarding facts that they discovered in the course of their investigation, specifically a 2011 arrest for public intoxication while carrying a firearm, and a domestic violence assault call in 2012 involving Mr. Moss's wife. To the extent that, addressing specifically, I think, the issues that are before the court, to the extent that counsel would like to argue that the notice item regarding the charges that were levied against the employer still before the court, respectfully, we would state that they are not. I believe what's happening is that the court is being asked to consider the weight of the evidence. Moss has challenged that weight of the evidence, but specifically the Civil Service Merit Board, as the trier of fact, heard the evidence, weighed it, and made a decision.
It sounds like,
the weight of the evidence.
ma'am, it sounds like part of the concern being raised is that they didn't hear all the evidence. Is that there was evidence that the appellant wanted to put on that the board refused to hear.
So there are three parts to that particular claim. One, the absence of a witness. Second, the limitation on the scope of examination of another witness. And third, that the counsel is not permitted to enter evidence related to other charges. Respectfully, we would say that there is no law that says that the panel must consider outside facts to determine reasonableness of the charge. As to the limitation of scope, there is no law that says that the chairman of this particular panel cannot implement principles garnered from the rules of evidence such that he decided in the hearing, the chairman decided in the hearing, that the line of questions were not relevant to what he was trying to hear about, and that was specifically the termination. The scope of examination that was being explored in that moment was relative to the purpose of the rally, not the termination itself or the physical altercation.
This is a civilian board, is that right? Is that correct? Civilian board?
Yes, Your Honor.
The chairman's not a lawyer, is he?
No, Your Honor.
So, but we're talking about weight of evidence that where they didn't agree to hear evidence. Would you agree with that?
I would agree that they decided not to hear evidence that they did not determine to be probative into the issue that they were trying to explore. And those were the facts relative to the termination.
All right, thank you.
The civil, I'm sorry, Your Honor.
Let
No,
me
it's all
ask,
Thank you.
let me ask you, Ms. Smith, in terms of probative evidence, would evidence to show that there were similar situations involving some incident where the fireman had a gun and that person was not terminated, would that evidence be probative of what should have occurred in Mr. Moss's case?
While it's certainly permissible for the chair to consider that information as to the reasonableness of the discipline that was imposed on the employee, he's not required, or the chairman of this particular board is not required to hear that information. In fact, he's required to establish that there is substantial and material evidence in the record to support the charges. He, in that moment, had addressed that concern and had decided that the purpose of this particular rally was not relevant to the facts aimed at the termination itself, specifically the physical altercation and what ensued at the Loudermill hearing.
Wouldn't it be particularly relevant in light of the testimony that Mr. Clark stated that the chief gave in that hearing?
To clarify, Your Honor, are you speaking to the claims about the 2011 arrest?
No, it's what I understood. Mr. Clark was quoting the chief to the effect that this termination was almost an automatic situation when you have a domestic situation involving a firearm. That's what I understood him to say. I may have misunderstood him, but so the question is that in light of that, and what Judge Armstrong just asked you, wouldn't that make that testimony about desperate treatment particularly relevant?
While disparate treatment,
as to the termination itself, not as to what happened at the event, but as to the termination. In other words, whether that was appropriate punishment for the event in light of what the chief testified to.
while the Civil Service Merit Board could certainly entertain that information, presently there's no requirement that they have to. And there was enough before the court in terms of the fact witnesses for both the altercation itself and the Loudermill hearing, where there were untruth and vague responses to very direct questions. He could have considered it, but he did not, and he was not required to hear that information, would be the position of the county.
What is he required to hear?
He is required to conduct a hearing that allows the terminated or the disciplined employee a meaningful opportunity to be heard, to confront and then cross-examine his witnesses.
And how is that decided? What's the standard? What's the standard of what it sounds like he can, from what you just said, he can hear whatever he wants to hear and not hear whatever he doesn't want to hear, whether it's relevant or material or has anything to do with the case, including the punishment that's to be determined.
The fact of the matter here is that the Civil Service Merit Board is vested with great and broad discretion, robust process to hear what they do determine to be relevant. They're required to provide that employee due process through the opportunity to be heard, the right to challenge and cross-examine witnesses, which was available to the employee here, and to determine the weight and the weight of the evidence that's before them, to actually make a determination as to credibility of the witnesses and to come to a conclusion as to the reasonableness of that discipline.
Let me ask you, Ms. Smith, you do agree that in these administrative matters, it's sort of a two-step process. First, you're looking at, is there sufficient evidence to show that the employee engaged in that conduct? So you get that proof. Okay, we've determined that he engaged in a certain conduct. And then the second step is to decide what is the punishment to be imposed. Because every violation, every offense doesn't automatically result in termination. There could be something different. There could be a suspension. There could be perhaps a reduction in pay, but it doesn't necessarily result in termination. And that's why, don't you think it's critical that an employee be able to put on evidence about what occurred in similar cases? What was the punishment imposed? Was it different from what's being imposed in this case? Wouldn't that be relevant and probative?
I think the trier of fact can determine in that moment what they do deem relevant to the facts being presented against them, the line of questions that they feel go directly to their authority to affirm, modify, or revoke an order of discipline that's appealed to it. I believe that challenging the weight of the evidence in this particular instance by using a standard that's not required of the Civil Service Merit Board is contrary to the standard of review that's present here. And specifically, it says the reviewing court shall not substitute its judgment for that of the agency as to the weight of the evidence. In that moment, the information that was before the tribunal and the line of questions that were being presented, the chairman had decided that he, one, had had enough information, at least as to what the purpose of the rally is, because I would state again that the line of questions that counsel is referring to were directly related to the purpose of a political rally relative to the impeachment of then President Obama, not to the altercation itself, which led to the termination of this employee, or at least to the charges being raised. So while it may have been reasonable, while it could have been relevant, it's not required for that tribunal to actually take in that evidence. They are permitted to do so, but they're not required to.
I'm sorry, maybe I misunderstood what you said. You said the chairman said that he'd heard enough about the purpose of the rally. I'm having some difficulty understanding how's that relevant, the purpose of the rally. I would think what he would be looking at, what was the conduct that occurred? The purpose is irrelevant, really. Did he get in an altercation with these two individuals? Purpose of rally is irrelevant as I see it. Did he engage in certain conduct that's unbecoming? And does this unbecoming conduct, is it appropriate that it results in termination? I mean, those are really the issues.
Respectfully, Your Honor. Respectfully, Your Honor, the Civil Service Merit Board, or let me start back, the Chief of the Fire Department, the Civil Service Merit Board, and the Chancery Court agree with what you just said. The purpose of the rally, which is what the questions were targeted at, and that was where the scope was limited as to witness Earl Mayfield. The purpose of the rally was not relevant to the line of questions. Specifically, the chairman of the board directed that they hear information relative to the termination, which would include the altercation itself. Right. That transpired between Mr. Ezell, witness Mr. Ezell, and witness Mr. Mayfield, that, the physical altercation between those two gentlemen and the employee here, not the purpose of the rally. So that was where the scope of the cross-examination was limited, and there really is no case law as to that point that says that he's not permitted to make that decision in furtherance of managing that hearing. And again, as to that part of disparate treatment, while the panel may consider that information, they still are not required to hear that information. What is actually in the record is an abundance of facts relative to a man who showed up at a political rally, got into a physical altercation, drew a weapon on two elderly men, was loudermilled, and in that loudermill hearing lied, was purposely vague. And when he was terminated, he was notified of those charges, and he was provided that meaningful opportunity to challenge witnesses, to present evidence, and now would contend that because of a failed opportunity to seek a continuance so as to secure testimony of one witness, he now wants charges completely reversed, which is an untenable argument in our opinion. He then wants to say that because the scope of cross-examination was limited to those relevant portions to the termination, not the purpose of a loudermill or purpose of a political rally, because the line of questions were limited, that he was denied due process in that way, we disagree. And then would state that because we want to talk about facts from some other case somewhere are relevant to his discipline, well, the tribunal here decided that it was not relevant, and there is no case law that says that they have to consider that information, though they are permitted to if they find it relevant. respectfully, all claims that he was denied his due process rights on those 3 grounds are without merit.
Well, if they don't offer proof of the disparate treatment, how are they able to make a determination about whether or not that was relevant?
I think the tribunal itself, under Massey, is required to hear that information that is presented to it, determine based on the record whether there is substantial material evidence to support the charge of discipline. If there's not, they do have the authority to revoke, modify, or amend that discipline. What was before the court, they felt satisfied the charges that were levied against him in violation of personal conduct as a public servant, as a fireman, which Chief Benson also said there's a great deal of trust that is given to these employees. They go into people's homes when they are sick, when they are dying. They go to save their property when it's burning. And to have a situation where you have an employee who thought it was prudent to show up at a political rally and draw a weapon on 2 retired veterans, it violates the public trust. Mr. Moss pled guilty. Now, I can appreciate that was the best interest plea, but he still did that. And a week after he did that, he was given a Loudermill letter. That Loudermill letter set out 2 charges, the conviction of arrest and failure to notify of arrest. And I can appreciate, too, that Mr. Clark says that he did notify his superiors of an arrest. He did, but not the 2011 arrest where he was arrested for being drunk in public carrying a firearm. So, for these reasons, the county would contend that there was substantial material evidence to support the charges, to support the termination, and he was at no point denied his due process rights under the law. Thank you.
Let me ask you one last question. Is there some test that we can apply to determine when it's proper or improper to deny evidence of disparate treatment? And does a commission have a test that it uses in determining when to allow it and when to not allow it?
May I have additional time to respond, Your Honor?
Yes,
Sure.
you may.
I would again reiterate that the Civil Service Merit Board has broad discretion here to hear evidence of testimony, to review documents, and weigh that evidence. As far as
Is that a no? Is that a no? They don't have it. They don't have any test they use?
I'm not presently aware of a test. I will say that.
Any additional questions?
No.
All right, thank you, Ms. Smith.
Thank
Mr.
you, Your
Clark,
Honors.
May I
you
proceed?
have 5 minutes for rebuttal.
Well, let me ask you a question before you get started, Mr. Clark.
Yes, Your Honor.
Do you have any case that says that it is error for such a commission to deny evidence regarding disparate treatment and making a determination about what discipline to impose?
Not from the state, not in the state courts. There, not in a civil service setting. In employment law cases under Title VII and things like that, there are hundreds of cases that deal with that. But I have not been able to find one in a civil service setting in the state of Tennessee.
All right, thank you.
Mr. Clark, I have a question for you also before you begin. You say that, I believe, to quote your words earlier, you said you had a whole stack of things you wanted to present as far as the disparate discipline issue. And I've read your briefs, but I haven't been through the full record yet. Did you actually attempt to present any evidence of any person, other employee, other than the one that had committed a sexual battery?
The only name that I set out in the record is Andre Gadsden. And then I asked for an offer of proof, and then they talked about legal counsel, and they're moving on.
And one other question, Mr. Clark, as far as the issue of being limited on the scope of your cross-examination of Mr. Mayfield, from what I understand, and you had essentially the board had not allowed you to pursue one line of questioning that you wanted to do as far as the rally itself. But did the board actually stop your questioning? Did they tell you you couldn't ask any more questions of any other type?
They told us to move on, that it wasn't relevant. And that was Mr. Espy was asking those questions, but he did not continue to ask the questions and have them repeatedly tell him to stop.
Attorneys get told to move on all the time in court. That happens all the time. But I'm saying, were you actually, or what was he actually told? You're done. Sit down. Don't ask anything else.
He told it was not relevant and to move on. And Your Honor, with all due respect, this is a hearing in front of non-lawyers who don't know anything about objections or evidence. And it is a differing function. I guess next time I'll go there, I'll mark everything that I have. But it is an untenable way to actually try to present evidence in front of these people. And I tried my best, but if I've answered your question, I would like to just make a couple points.
Well, let me ask you, what relevant evidence were you prevented from presenting?
That numerous people of the Shelby County Fire Department have been retained after actually being arrested for much more serious crimes, and after a hearing. That was the evidence that I was trying to get in on disparate treatment. With respect to the cross-examination being stopped on the limitation of cross-examination, that was a minor event. That is an issue, but I don't think it's the major issue. The major issues are confronting the witness and disparate treatment. And in getting back to one thing that you asked Ms. Smith, Judge Armstrong, was dealing with the two functions that we have, whether the conduct occurred and what the discipline is. And that is the whole question about disparate impact and how they do it. To be clear, Judge Benson said, or Chief Benson said, in your experience with the fire department, the discipline that was rendered to Mr. Moss is in accordance with what you have seen happen in other employees. Is it consistent with discipline that has been rendered in the past? His answer is, I believe it has been consistent with the discipline that's rendered. So it would at least come in to impeach him. And finally, I only have a couple more seconds. I think Chancellor Golden asked a number of questions which point out my frustration with this. I don't know the standard. They're saying Chief Benson wrote a letter and all they have to do is uphold that letter. Chief Benson's letter didn't even identify that Mr. Moss was put in a headlock. The whole process is arbitrary, as they can only hear the evidence that they want to, that supports their decision. Thank you, Your Honor.
Thank you, counsel. We will consider the case and render an opinion as soon as we can.
Thank you, Your Honors.
Thank you, Your Honor.
This honorable court is now in recess until 10 a.m.